y'all, it's Squid. Welcome back to the channel. I have not streamed all week. I have not streamed since Saturday. I have a cold from hell. So if I start sounding like I'm a Minnie Mouse, um, I'm kind of sounding like I'm a pack-a-day smoker, and it kind of hurts to talk. So we're going to keep this nice and short and sweet. Sarah Boone's hearing was today. It is not out yet. They don't ever record it live or let people see it live. They record it and then post it later. When it oh sweet, Judge Fisk denied the motion to remove Mata. For those of you who don't know, in the Laura Owens versus Clayton Eckerd Tonsil Twins case, her lawyer Gingras filed a motion to remove Mata, saying that Mata was biased because Mata's dad was at the courthouse, which he's a member of the public. He's entitled to be there. And also that, like, the motion was just really unprofessional and screamed of, I'm a sore loser, is pretty much, like, the most politically correct way I can say it. Some of the things he said was, I would never, if I was a lawyer, even in medical, if I wrote something with that laced with attitude in a medical chart, I'd be getting an ethics complaint. Hey, Flash fan and Sir Frank, John, I know you're over in Danny's chat, but I appreciate you stopping by and doing the modelly stuff. Robert, Roy, as always, Hung Hero, feel better. Something's going around. Several people at work are suffering the same. Yeah, Mr. Squid came home Saturday and wasn't from work and was not feeling well. Saturday, Sunday, and then Monday I spent, since there was really nothing going on in the world of the cases that I'm following. There's always something going on in the Laura Owens case, but I'm so far behind in there that I have to figure it out later. I have to do a stream with somebody who knows what the heck they're talking about and has been keeping up with it to kind of re-enlighten me. But the one thing we are going to talk about today is his tweets, because as a lawyer, I wouldn't tweet anything like that as a layperson, as a rando. Like, I would not be tweeting about an active case. I just, wow, what on God's green earth gives you the audacity to think that that's appropriate? Like, that is not appropriate from any professional. Like, I don't understand it. And I love to understand the psychology of why people do the things they do. And I love the deep dive into psych. However, I cannot figure this dude out except for attention. He has a narcissistic, in my opinion, he has a personality disorder. There is something there that screams for attention, just like Laura. He and Laura are two peas in an effing pod. Yeah. For those of you who don't know, and me talking about my community being affected, according to some people, is bullshit. If you decide that you want to call my streams bullshit, being that I believe the comment was, and before I block this person, I'm going to give them the 15 minutes of fame that they want. Here was the, I have to go to my Twitter because I posted it on my Twitter. So if you want to see exactly what was said, you can go to my Twitter page. But Tahar Ka X said, 14 minutes in and all I hear is bullshit. Your channel sucks. This was on the Mia Bailey case review. I went back and I watched the first 14 minutes to see what this person was talking about, because they might have a valid point. I might have been talking about something weird and not appropriate. I was talking about hurricane or tropical storm, however you want to call it, Debbie, and how it affected my community, and how my community has been, for lack of a better term, devastated by the amount of damage. I have friends that lost things. Their houses are fine now, they have some damage, but they're missing like kids' toys, washers and dryers are done, um, appliances. So even if you think of someone who didn't lose their whole house, um, like hundreds of dollars worth of food, um, like when we didn't have power, like the little things, like your bed was wet. Your house might be salvageable, but you need a new mattress, new sheets, because your stuff was covered in swamp water. Like you need new furniture. Like people don't take into account all of the little things that add up. And I said, thank you for the engagement, hon. It's appreciated. I'm glad you think talking about charity and helping my community sucks. It tells me all I need to know about you, and I don't want your negativity on my channel. Good riddance, and off you fuck. Taking a phrase from Megan that I love. Off you fuck. So, yeah. Well, Flash Fan, he never said that. Yeah, he said basically the first 14 minutes of that stream, I was talking about how Hurricane Debbie affected my community. And he proceeded to say that that was complete bullshit. So the kind of person that says that is the kind of person that I really don't want on my streams anyway. So before I block them, I wanted to give them the 15 minutes of attention and fame that they were asking for. Because the only people who write comments like that are attention-seeking little brats who think they're entitled to tell everybody what they need to talk about. So it's one of those things of, I want to give this person the 15 minutes of fame. Bless your heart, sweet pea. Go fuck yourself. And Roy, thank you. I just got your PayPal. I appreciate you. The money, I'm doing a charity stream on Saturday at 8 o'clock. The money that I raise will be going to a local church, a Baptist church that was making meals for people, first responders, people helping clean up, and people affected. They had their doors open from 9 a.m. to 9 p.m., cooking, providing shelter for people because it's still hot as sin down here. And just because, like we didn't have air conditioning for 8 hours, and our house got up to almost 80 degrees and 75% humidity inside. So like this crap is real. Just because our house wasn't affected like by the water, we still had cleaning up to do because we had to open our windows during a hurricane. We had to open our windows during a hurricane to get some breeze. And then we had to clean out all the windows, and we had towels in each window, so it's a lot of laundry and just a lot of things that people really don't think about. But we made it through unscathed. Others were not so lucky. So any money that is raised will be going to the local church who was feeding people, and a local food bank called Feeding the Borough, who has been working overtime trying to help people who lost everything, all their food. It's a food bank, but it's a local community food bank. It's not, like Hunger Task Force or something that's national where you don't exactly know where your money's going. Like I feel like these two groups are the best people to give their money to. So exactly the money that you donate, that it's going to help the local community. Not like the Red Cross where you give them money and you don't know if it's helping your community or it's being sent elsewhere. And I appreciate those who have told other people about what I'm doing. It means a lot to me, and I appreciate it. I've already raised $75, which doesn't seem like a lot, but it's $75 that these two organizations didn't have before. So it's kind of I'm grateful to be helping, because not everybody was as lucky as we were. It's just bad. Like it's just there's dams that are still in, they're not as bad as they were, but they are still one heavy rainfall away from being breached. So they're trying to, I say I'm not doing anything that's out of my expertise, but we are just hoping that they get them fixed and that they don't breach anytime soon, because we're like Florida. It can go from sunny and 85 to a storm and like that. I'm trying. Like, I know people who are better off than I am, and I know people who, like, it's the little things, like, hey, all my stuff got um all my stuff got destroyed, and like my house is okay, but like water got in my car and now I need to have, my car repaired. Well, that's not in this economy, that's not something that a lot of people planned for. And you always, yes, we should have a storm fund, but at the same time, you never think it's going to happen to you until it does. And sorry, I'm phlegmy, so if I like have to mute and like cough up a lung, I'm trying not to lose my voice. So, yeah, we're watching that one too. So the one thing I wanted to get to today was I wanted to get to the Sarah Boone, the hearings today, but I was sent this by two different people. The TV channels who have been able to film it filed a motion to keep the evidentiary hearing open. So we are going to get into, but in this economy, people's emergency funds are used to pay rent and get basic groceries and like things that you never thought were emergency funds before. And now you're like, oh, I need to put gas in my car, but it's $3.25 a gallon. And like, I have to drive 50 miles to work every day. Like it's these things that maybe in 2020, maybe in 2019, 2018, these people who had these emergency funds were actually for emergencies. Now they're just for basic needs. Hey, General T. Hey, Denise. There are times that the Storm Rainy Day Fund gets used for other emergencies. Yeah, and that's true too. I feel like this motion is just because they can. As much as I like covering this case, this is one of those situations where I feel like the media does not need to be in. So let's get to this. Window. And now that we're 14 minutes in, that's 14 minutes of bullcrap. If you are on Replay Crew and you ever want to skip ahead through the BS and get to the meat of the topic, just skip to like minute 15 and you'll pretty much be able to find it. That was the other thing. This dude was on Replay Crew. So it's like you could have easily skipped ahead, but no, you wanted your attention, so I'm giving it to you. Hi, Sweet Pea. All right, let's zoom in a little. Ooh. All right, State of Florida versus Sarah Boone. Motion to intervene for the limited purpose of opposing closure. WFTV TV, Channel 9, moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings. In support thereof, the WFTV states as follows. 1. WFTV has covered the murder of Jorge Torres and the arrest, investigation, and prosecution of defendant Sarah Boone. Reporters from WFTV attend court proceedings and rely upon state, county, and local public records, as well as judicial records, as part of their news gathering process. This court set a physical viewing of the evidence for September 3rd, 2024. and is set to consider the media's attendance at the viewing during the hearing on August 14th, 2024. 3. Any closure of the physical viewing directly affects the media's and the public's right to monitor this important criminal proceeding. As such, WFTV has standing to intervene and oppose any requested closure, see e.g. Miami Herald, Public v. Lewis. So I have a problem with this right off the bat. Like, any closure of the physical viewing directly affects the media's and public's right to monitor this important criminal proceeding. No, it doesn't. This is just lawyer talk for I want in and you won't let me. Like, in my opinion, this is not legal advice. I'm not a lawyer, but like, this is just a wah, we want in. I don't think this affects the right to monitor this proceeding. I think this gives Sarah Boone the opportunity to view things in private. Like, it's yes, hold on one second. Oh, she grabbed her bike and left. Works for me. This is just the TV news channel saying we don't want to be left out. But this is something that needs to be private, in my opinion, in order to not taint any jury and the evidence. So if everybody knows the evidence that they might bring in before, is she really getting her chance at a fair trial? And yes, do I think she's guilty as sin? I do. However, this could be if the jury or if the media is let in and the jury is tainted in any way, or jury pool is tainted in any way, this could be an appealable thing. And then that just means that it's longer that we get to deal with Sarah Boone instead of her just going quietly into the sunset. 4. WFTV would like to be heard in this matter and asserts that any requested closure should be denied. 5. Florida has traditionally served as a model for open government and courts. It is well settled in this state that criminal court proceedings are presumptively open to the public. The Florida Supreme Court has stated that, quote, a trial is a public event and what transpires in the courtroom is public property. All they will most likely be doing is saying, do you have objections to this? And she'll say yes and no, and that's it. So the issue is those items being on camera and the jury, anybody who watches can see those items, and I don't believe that those items should be seen before a trial. If these were just two sets of lawyers going over it, it would be private. So just because it's being done in a courtroom and not in a conference room somewhere, why should it be public? Just because she's pro se. That's where if there was an attorney present, they would not file this motion. It's a very stupid motion. Yeah. If there was an attorney present, it wouldn't be this evidence hearing or evidence viewing would not be done in a courtroom. It would be done in some conference room somewhere in a police station with the cops, the prosecution, and Sarah's lawyers, and would not be public at all. So why, just because she's pro se and they're doing it in the courtroom because she's in jail and can't go anywhere else, why all of a sudden should it be public? I don't think that it should. This is one thing that I'm going to side with. Yeah. She is. So if I type any weird stuff in the chat, somehow Baby Squid got onto my stream on her iPad. And yes. And if you see any weird comments, it's because she wrote them. So, like, darn good. I was just typing that sentiment. Yeah, I just like not to be on Sarah's side, but just to play devil's advocate is like, would that hearing be public or be in a courtroom if she had lawyers? No. Therefore, it anything that should have been private if she had a lawyer should still be private. So, 6. Therefore, when considering a request to close court proceedings, this court, quote, should begin its consideration with the assumption that a pretrial hearing to be conducted in an open court, unless those seeking closure carry the burden to demonstrate a strict and inescapable necessity for closure, unquote. In order to justify closure, the moving party must meet an exact standard and show A. Closure is necessary to prevent a serious and imminent threat to administration of justice. B. No alternative other than a change of venue would protect the defendant's right to a fair trial. And C. Closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Here's my other issues. Like, closure is necessary to prevent a serious and imminent threat to the administration of justice. If this was not in a, I repeat, if this is not in a court, or if this was not in a courtroom, it would not be viewed. If she had a lawyer, this would not be in a courtroom. Therefore, anything that would normally happen outside of a courtroom and is only happening because Sarah is pro se should still be private. Like, good Lord, the woman is entitled to some level of privacy. I don't like her, but still, like, yeah. I'm really hoping that Kranick just looks at this and goes, no. No alternative other than a change of venue would protect the defendant's right to a fair trial. Letting the public, including possible jury members, seeing the evidence before a hearing would affect a fair trial. Do we all think, 99.9% of us think she's guilty? Yes. However, it still does not, everybody is entitled to a defense and a fair trial. 7. For closure, it is not necessary to prevent a serious and imminent threat to the administration of justice. Importantly, the fact that the proceeding will involve viewing evidence does not alter this court's Lewis analysis. See State v. Lugo. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. Sorry, it's very hard to read. It's very hard to read and not sniffle at the same time. And I'm trying to get healthy as quickly as possible so I can be healthy for Saturday. Suppressing a defendant's statement that included, quote, potentially damaging admissions, but refusing to seal the statement because even where pretrial publicity and publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. But can they, though? 8. And any attendant publicity is not synonymous with prejudice, as the Supreme Court explained. Prominence does not necessarily produce prejudice and juror impartiality. We have reiterated, does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion of the merits of the case. Every case of public interest is almost all, as a matter of necessity, brought to the attention of all intelligent people in the vicinity, and scarcely anyone who can be found among those best fitted for jurors who has not read or heard of it. and who has not some impression or some opinion in respect to its merits. A presumption of prejudice, our decisions indicate, attends only the extreme case. Fairchild was there to be locked in a suitcase for 24 hours in the Everglades. Survive the gators and she's free. Oh, hi, J. Katie Buck. How are you? So yeah. This is I don't like this. What they basically want is trial by media, and that's not fair. Her rights matter too. Yes. And as evil of a person as I think she is, she still has rights. Skilling versus U.S. See also Nebraska Press Association v. Stewart. Pretrial publicity. Why is that word so hard today? Even pervasive adverse publicity does not inevitably lead to an unfair trial. As such, media attention alone is not sufficient basis for closure. See Cosma, noting even massive pretrial publicity about a case is not enough to show a serious and imminent threat to the administration of justice or to the denial of fair trial rights. 9. The second, alternatives to closure exist to protect the defendant's fair trial rights. For example, traditional techniques during jury selection can be used to insulate the jury from the consequences of publicity. See Lewis, noting that when considering when there is an imminent threat to a defendant's fair trial rights, a court should consider, quote, whether traditional judicial techniques to insulate the jury from the consequences of such publicity will ameliorate the problem. State v. Sharrow. Finding defendant failed to meet burden to justify a closure of suppression hearing, in part because the court could effectively protect the defendant's right to a fair trial through the jury selection process and to insulate an impaneled jury from additional coverage. Yeah, it really does sound like they want everything streamed. And I can understand wanting content because as a content creator, it is nice when content just magically falls into your lap. However, just because it makes good content doesn't mean it should be content. This is just their lawyers trying to grandstand, and I don't think Judge Cranick will go for it because he sounded pretty on Sarah's side with the way he was talking about keeping this private. Yeah. Yes. And it's been almost 5 years already. The last thing he wants is it to be appealed and overturned on appeal. Like, it's just no. Oh. Okay. She's got something in Spanish. Or wait, that's like, I think that's Korean. So we'll see how this goes. 11. Rather than a hindrance to the administration of justice and Sixth Amendment rights, heightened public attention only increases the need for, quote, appearance of fairness so essential to public confidence in the system, unquote. Press enter company v. Superior Court of California. Reading is hard today. Publicity is vital to an open and accountable judicial system. I agree in a way. As a former Supreme Court Chief Justice Berger explained, without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. 12. Closure of judicial proceedings should be ordered only when there is a serious and imminent threat to defendant's right to receive a fair trial. And even then, alternatives must be considered and restrictions must be narrow. In this case, there is no strict and inescapable necessity for closure, and this court should deny any such request. Wherefore, WFTV requests that this court allow it to intervene in this matter for the purpose of opposing closure and deny any requested closure of the September 3rd, 2024 proceeding. Respectfully admitted, Shulman Fulgate, Rachel Fugate. It would be a woman that would write this. Like, it would be a woman that would write this. So there's that. Yeah, I don't think that the judge should approve this. I think that anything that would have been private if she had an attorney should be private when she's pro se. And I'm like that not just with her. Yeah, she wrote that like everything is going to be denied. It's like, no. You have access to a lot of things. Just not an evidence hearing or evidence viewing. It's not really a hearing. It's just, but anything that would be closed doors, if she had a lawyer, she'd be closed doors to a pro se defendant. Like, I understand that, like, it has to be in a courtroom because Sarah's in jail, and obviously we can't, it's impossible for her to go anywhere else to view this evidence, but just because it's in the courtroom doesn't mean it should be public. This is not a public display. This is Sarah defending herself. How? I think you are having so much difficulty with the word publicity because it starts with a P, and if you cough, yeah. I'm very phlegmy, and publicity makes me feel like I want to spit, and it's very uncomfortable to say. What's next? Are they going to ask to hear sidebars? Yeah. I mean, I can't wait. I hope that, like the Depp trial, these sidebars are released eventually, because I would love to be a fly on the wall during those. All right. The other thing I wanted to get to, and I didn't have time when I got home to get into it, but yeah, if not a mistrial, definitely an appealable topic. I would say appealable offense, but that didn't sound right when I said it in my head. Sarah Boone's court hearing is still not out. But we are going to go to Twitter or X or whatever you're calling it these days. I don't like calling it X because I don't like looking at my profile and going, oh, you have 400 X's. Excuse me, sir? I have 400 what? However, I wanted to go, and if he hasn't blocked me. So if he blocked me, this is not going to work because if he blocked me, it's not going to Yep, I wanted to go to Gingras'. I don't have the information. I could go to Discord and see if they dropped it on the Discord. But what I wanted to do was go through all of Gingras or whatever the heck his name is. I stopped trying to keep up because I want to know what his tweets say. Oh. All my exes live in Texas. Yeah, once I figured out that they didn't live stream it, they recorded it and then dropped it later. I never was super interested in like trying to catch it or schedule a live stream when it was going on because we wouldn't have been able to see it anyway. So he did set it to private, but it came up in my last searches. So if you go to your search history, it's still there. So we can still see it. So I will share. So I will see what I just went to his page now. Ooh, look at that. Hey, I didn't have to search for it. He posted it like a dum-dum. I believe they're going to stream the trial live, which they normally do for all trials. But I just think with the hearings, like there's so much unknown about it, whereas the trial, like we know what to expect in a trial. The only reason I can think about that too is Court TV is currently busy streaming other trials. So a court hearing for Sarah Boone that's been going on for 5 years is not the most pressing matter. So they record it and live or drop it later. So I didn't have to search for the ruling. Gingras posted it himself. Laura Owens v. Clayton Eckerd, minute entry. This court has considered petitioner Laura Owens' notice of change of judge for cause, memorandum and affidavit of support, hereafter the Rule 6.1 motion, and the separate affidavit of David S. Gingras in support of petitioner's notice of change of judge for cause, hereafter change of judge for cause, filed 7/11/24. Pursuant to Rule 6.1, Arizona Rules of Family Law and Procedure, the Rule 6.1 motion was referred to the Family Department presiding Judge Rhonda Fisk, this court, for ruling. For the reasons set forth herein, the Rule 6.1 motion is denied. Denied. Hey, Jess, how are you? Oh, my goodness. Oh, my goodness. The footnote, the Rule 6.1 motion was filed after Judge Mata's 6/17/24 ruling and before petitioners filed various post-trial motions. Judge Mata prematurely ruled on the post-trial motions. That ruling was withdrawn via a 7/19/2024 minute entry ruling filed 7/23. Now that this court has ruled on the 6.1 motion for change of judge, Judge Mata may rule on the pending motions. Can't wait for that. Rule 6.1d5, if the court determines that the party who filed the affidavit is not entitled to a change of judge, the named judge may proceed with the action. This is going to be funny. Denied. Petitioner's Rule 6.1 motion seeks to disqualify for the assigned family court judge, Judge Julie Mata, quote, on the basis of bias and prejudice within the meaning of Arizona Section 12-409-5, see Rule 6.1 motion at 2. Specifically, petitioner alleges that Judge Mata purportedly did the following. 1. Performed an independent investigation into the facts of the case, and in so doing, considered and relied upon information posted on the internet about the case. And 2, engaged in ex parte communications regarding this case with her father, Harry L. Lowe, who appeared at the trial as a spectator. Oy vey. I just can't. Like, Gingras did he actually expect this to go through and be approved? Like, he's just wasting time and Laura's money. As a threshold matter, this court apologizes to the parties for the delay in issuing this ruling. The court had technical difficulties opening the compilation CD included with the affidavit. When opened with Windows Media Player, the file entitled produced an error message, "We can't open Judge Mata's dad compilation." It uses unsupported encoded settings. With technical assistance, the court finally was able to open and reviewed the compilation CD using VLC Media Player. After reviewing the CD, the court prepared this ruling. So the judge, well, that's to be determined. But the judge saw all of us in Rosalind's live stream. My ugly looking face. 1, timeliness of the Rule 6.1 motion. Respondent contends that the Rule 6.1 motion is time barred under ARS 12-409B5 on the basis that, quote, it was filed after final trial and final judgment under Rule 78. See response at 4. This court finds that the analysis as to timeliness is more nuanced than respondent suggests. A Rule 6.1 motion for change of judge for cause must be filed, quote, within 20 days of discovering that grounds exist for a change of judge. Rule 6.1c. This court must at least consider the factual allegations to determine whether they are time barred. Pretty much. And I got this this directly from his website. He posted this on jingrislaw.com. So I didn't have to search for it. He posted it on his Twitter if anybody else wants to go read it for themselves. The Rule 6.1 motion and affidavit allege as follows. Judge Mata held an evidentiary hearing on 6/10/24, hereafter the June 10 hearing. See Example E to affidavit. Judge Mata's father, Harry Howe, attended the June 10 hearing as a spectator and spoke to other people in attendance. See affidavit 66-67. Individuals Dave Neal and Megan Fox, among others, live streamed and posted on social media various interviews with people who spoke to Mr. Howe at the hearing. See ID and an accompanying compilation CD. On or about 6/17 at 10:10 a.m., petitioner's counsel emailed Judge Mata's division and respondent's counsel that the statements made on social media had just come to his attention and warranted a change of judge for cause. See Exhibit A to affidavit at 11:58 a.m. Judge Mata's division sent a response email instructing counsel to file appropriate motion to bring any issue to the court's attention. See Exhibit B to affidavit. Footnote 2. The Rule 6.1 motion alleges that these two actions separately violated Rules 2.9a, initiating, permitting, or considering ex parte communications outside the presence of the parties or their lawyers, and 2.9c. A judge shall not investigate facts in a matter independently of Arizona Rules of Judicial Conduct. It is not for this court to determine whether Judge Mata has violated the Arizona Rules of Judicial Conduct. Moreover, the Rule 6.1 motion makes vague allegations of violations of petitioner's right to due process of law under both the United States and Arizona constitutions. See Rule 6.1, motion at 1:11. Again, it is not within this court's purview to determine whether Judge Mata made errors in her findings of fact and or conclusions of law that violated due process and or warrant a new trial. Oy vey. On 6/18 at 8 a.m., Judge Mata's 6/17/24 under advisement ruling was filed hereafter the June 17 ruling. See Exhibit C to affidavit. The June 17 ruling contained the detailed findings of fact, including the following findings. Dr. Samantha Deans further testified that Planned Parenthood is not open on Sundays when petitioner testified she sought care July 2nd, 2023. Identified at 10, the trial transcript from the June 10th hearing reflects that Dr. Deans did not testify that Planned Parenthood is not open on Sundays. See Exhibit E to affidavit. Based on the foregoing, the court finds that Rule 6.1 motion filed 7/8/24 was timely filed. In making this finding, the court acknowledges that within 20 days of 6/17 is Sunday 7/7/24. Given the circumstances of this case, including the fact that petitioner's counsel was on a previously disclosed vacation from 6/10 to 28/24, the court finds that the filing of the motion the next business day, i.e. Monday, 7/8/24, was timely. The affidavit also details various facts and rulings that petitioner's counsel alleges constitute a summary of pretrial judicial bias. See affidavit at 9-12 and 37-51, and a summary of judicial misconduct and bias at trial. Rule 6.1, motion at 13, alleging Judge Mata manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings. The court finds that these events that the petitioner contends constitute misconduct and bias occurred and were known to petitioner more than 20 days before she filed her Rule 6.1 motion. The court will limit its evaluation of the Rule 6.1 motion solely to the two allegations identified in the second paragraph of this ruling. So basically, they're only allowed, or she's only going to look at the two things that happened in the 6/10 hearing. 2, request for hearing. Petitioner has requested that the court hold a hearing and order subpoenas ad testificandum, Latin, that I'm not good at, for Judge Mata and Harry Howe. A presiding judge reviewing a Rule 6.1 motion for a change of judge as a matter of right has discretion as to whether to hold an evidentiary hearing. See Rule 6.1 D2. The presiding judge may hold a hearing to determine if determine the issues raised in the affidavit, or may decide that the issues based on any affidavits and memoranda filed by the parties. This court denies petitioner's request and will decide the Rule 6.1 motion on the affidavit and memoranda filed by the parties, as well as those items on the docket of which this court takes judicial notice. Denied again. How many times can he be denied in one motion? 3, analysis of cause for change of judge. A party seeking a change of judge for cause must establish grounds by affidavit, Rule 6.1a. One of the grounds which may be alleged for changing of judge is that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. Arizona Statute 12-409b5. The sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affidavit's subjective belief. Rule 6.1d5. Case law instructs that in Arizona, a party challenging a trial judge's impartiality must overcome with presumption that the trial judges are free of bias and prejudice. Stagecoach Trials, MHC, LLC, versus City of Benson, quoting Simon v. Maricopa Medical Center. Judicial rulings alone do not support a finding of bias or partiality without a showing of extrajudicial source of bias or a deep-seated favoritism. A change of judge for cause is not warranted if based merely on speculation, that's all he has, suspicion, apprehension, or imagination. Laura has the imagination of, like, I can't even. She needs to write books because she has such an imagination. Hey David, good afternoon. Identified internal punctuation and citations omitted. Instead, the party seeking to notice the judge for cause must prove bias or prejudice based on a preponderance of the evidence. He has no evidence. I believe that Judge Fisk said, just because you didn't like what was ruled means you are being a crybaby and need to build yourself a bridge and get over it. Very well stated, Denise. Yes, just because you didn't like the rulings doesn't mean they weren't correct. Just because you didn't like the rulings doesn't mean they were biased. You have just lost your I don't know. He's got this like rose-colored glasses or like beer goggles or something. Like he is not seeing what the rest of us see. Ugh. The court will separately consider petitioner's two claims of bias and or prejudice. A. Allegation of independent investigation by Judge Mata. Petitioner correctly points out that Judge Mata's July 17 ruling contains a factual error, i.e. the transcript from the June 10 hearing shows that Dr. Samantha Dean did not testify that Planned Parenthood is not open on Sundays. See Exhibit E to affidavit. Judicial rulings alone almost never constitute a valid basis for bias or partiality motion. State v. Ellison. This factual error can be corrected through a post-trial motion or appellate proceeding. It does not, standing alone, indicate bias. See Stagecoach Trials. To demonstrate bias, petitioner asks this court, Rule 6.1, Motion at 7, to infer that Judge Mata's erroneous findings constitutes irrefutable evidence that she performed a secret, undisclosed investigation in the facts of this matter. She might have just looked at a damn calendar and noticed that it was a Sunday. Just, anybody can look at a calendar. It doesn't mean you're biased. That she performed a secret, undisclosed investigation in the facts of this matter. Affidavit 93, and copied that findings from a post on social media. In support of this position, the affidavit includes snips of a 6/10/24 comment on petitioner's counsel's website, Planned Parenthood isn't even open on Sundays in LA, and comment posted by anonymous Twitter user 610 at 5:08 p.m. It was Sunday and all LA Planned Parenthood's locations are closed on a Sunday. The court finds petitioner relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. The record evidence reflects conflicting testimony about the day, date, and location that petitioner obtained an ultrasound, admitted as Exhibit B28, which petitioner admitted to altering, basically saying your client lied. Oh. I'm so glad that this judge is I'm liking the way she's writing this. Just laying it all out. Petitioner testified that when she was in California on a, quote, weekend, she had an ultrasound done under a, quote, fake name at Planned Parenthood. See Exhibit E, 17, 20 through 19, and 8. Before trial, petitioner had provided a declaration stating that the ultrasound occurred on 7/2/23. At trial, she changed her testimony to say it was unspecified weekend in late June 2023. Petitioner further testified that she had altered the ultrasound to reflect the incorrect date of 7/7/23 and the incorrect provider, Smile, instead of Planned Parenthood. Dr. Deans testified that she had reviewed the altered ultrasound and available medical records to prepare a report. Dr. Deans expressed concerns about the legitimacy of petitioner's medical records. Dr. Deans confirmed that Planned Parenthood's national guidelines require identification at the time of visit to confirm the identity of a patient. The patient cannot be seen anonymously. Dr. Dean's testimony did not address which days of the week Planned Parenthood offices were open. Based on the foregoing, the court finds that when determined by an objective standard, not by reference to the affiant's subjective belief, Rule 6.1 D5, petitioner has failed to show by a preponderance of the evidence that Judge Mata's findings that Planned Parenthood is not open on Sundays reflects bias or prejudice against petitioner. Moreover, although not dispositive of the issue, the court finds that this singular factual finding is of little to no importance given the rest of the findings in the July 17 ruling. Basically, there was so much other BS that Judge Mata saw that this was inconsequential and had no effect on the overall ruling. Hey, Toy. Gingras dug himself a hole. He can only do two things now: keep quiet and hope all goes away, or eventually dig an even deeper hole for our amusement. This man does not know when to stop talking or stop typing. Someone needs to take away his computer and disable his disable this man's Twitter account for his own good. Like, for his own good. Like, just B, allegation of improper ex parte communication with Harry Howe. Petitioner alleges that Judge Mata's father, Harry L. Howe, was present in the overflow room during the trial and spoke with several of respondent supporters during and after the trial. Petitioner's counsel admits the mere fact Judge Mata's father attended the trial is not the primary concern. For purposes of deciding Rule 6.1 motion, this court accepts these allegations as true and finding that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and speak to other courtroom observers. Petitioner asked this court to infer that various statements made by courtroom observers about Mr. Howe confirmed that Judge Mata was biased or prejudiced against petitioner. Petitioner's counsel acknowledges that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. Nevertheless, petitioner's counsel asks this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. Applying a, quote, objective standard, not by reference to the affiant's subjective belief, Rule 6.1 D5, the court carefully reviewed the compilation CD and considered in context each of the comments identified in petitioner's counsel's affidavit. Given the seriousness of the allegations, the court had made best efforts to provide both the context and verbatim language of the various statements, though admittedly the audio of the compilation CD is very difficult to understand at times. Thank you. She's down here on her iPad. I have to give her her iPad to get her to sit still because she's still not feeling good. But her body is like, I still want to move. And it's like getting a toddler to sit still when you know they're sick is not a good thing. Statements by Hava Darby. Petitioner alleges that Miss Darby, who speaks between 0 and 40 seconds in the compilation CD, also made statements which appear to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. The first video clip on the compilation CD depicts a virtual meeting among 9 participants, including one with the screen name Hava Darby. Miss Darby holds up in her phone and makes the following statement. I ran into Judge Mata's dad, and I was on that 9-person participants. That was hosted by Rosalind Duke, and I was one of those nine people. So this judge now knows my face. I ran into Judge Mata's dad in the parking lot afterwards, and I asked him, like, well, what did you think? He was like, I got to show you something. Female voice, what? So he whips out these papers in his hand, and did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied. This request for findings of fact and conclusions of law proposed findings. Male voice, that wasn't denied? That wasn't denied. Okay, so anyway, did anybody get a copy of this? He was saying, Julie told me, this is just, you dad, you got to read this, and printed out a copy. For purposes of deciding Rule 6.1 motion, this court accepts that the scenario recounted by Miss Darby might have occurred, though Miss Darby appears not to be clear as to exactly what she is talking about. This court finds that the fact that a trial judge might have told a family member that she was presiding over a case and might have provided a copy of a publicly available finding, example, the request for findings of fact and conclusions of law and proposed findings, filed 6/3/24, neither proves by a preponderance of evidence that the judge was biased or prejudiced, nor proves that she told her family member how she intended to rule before the case was tried. Oy vey. I just can't. 2. Statement of Dave Neal and individuals speaking with him. Petitioner's counsel's affidavit further alleges that an individual named Dave Neal made remarks to signal the person speaking that they should not disclose further information regarding the comments they claim to have received from Judge Mata's father, because her believed that she would expose judicial misconduct and bias on the Judge Mata's part, requiring a new trial if those facts were exposed. The second video clip on the compilation CD depicts a group of people standing under an awning. The bottom left corner of the screen says Dave Neal Rush Hour Podcast. In the foreground, there are two men talking, one in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. While these two men are talking, a woman in a hat approaches and joins their conversation. A woman on left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. Male in red shirt. Judge Mata's dad was in the court with us. Dave Neal. Judge Mata's dad? No way. Male in a red shirt. It's in the court in the side room where we were. Judge Mata's dad was sitting there. Dave Neal. She did fantastic. Woman in hat interjecting. I said, Harry, that's really nice of you. You want to be here to support your daughter. He said, oh, no. I've been hearing about this. I'm here for the circus. Group laughs as woman in hat walks away. Dave Neal, hold on. We don't need a mistrial. Additional group laughter. So we could get him some scones. Yes, scones. 10 seconds of video deleted per podcast timestamp. Woman on left. I was inaudible, waiting to get in. We just heard. Oh my God. The fact that, hey, Simon, all the best. Yeah. Woman on left. You don't look like the demographic. How did you hear about this case? Inaudible, my daughter. There you go. Hey, that's a woman on left. And he was reading the case files. I'm sure he was. I mean, he was probably a judge. I feel like it runs in the family. Woman on right. Inaudible. He did not tell me any information about her thoughts. Right there. He did not tell me if she told him anything. Right there. Female voice. Yes, Judge Mata's dad and I were just sitting right next to him. Oh, I'm sure, yeah. Again, for the purpose of deciding the Rule 6.1 motion, this court accepts that certain facts recounted by these courtroom observers might have occurred, i.e. Mr. Howe might have informed an observer before hearing that he had heard about the case from Judge Mata. Mr. Howe might have told an observer he considered the hearing and additional goings-on to be a circus. Don't we all? And Mr. Howe might have been reviewing paperwork related to the case. When viewed by an objective standard, Mr. Howe's alleged statements and actions do not prove by a preponderance of the evidence that Judge Mata was biased or prejudiced, or that she told her family member how she intended to rule before the case was tried. This court also finds that certain statements made by the courtroom observers reflected nothing more than mere conjecture, like Mr. Neal's statement that Mr. Howe was probably a judge. I feel like it runs in the family. The court further finds that this video reflects that Mr. Neal's remark, we don't need a mistrial, after the speaker started walking away, was made in jest. Oh, a judge with a sense of humor. A judge who understands a sense of humor. As evidenced by his and the onlookers' laughter and his agreement with another bystander that they should get him a scone. The court concurs with petitioner's counsel's subjective belief that respondent supporters gleefully celebrated Judge Mata's father's attendance at the hearing. See Rule 6.1, Motion at 12. And that the supporters' actions, and perhaps even Mr. Howe's alleged actions, can be perceived to have made a mockery of these proceedings. This court declines, however, to impute bias or prejudice to Judge Mata based on statements made by respondent supporters, whom petitioner's counsel characterizes as generally not honest. Yeah, so it's like saying, hey, we're not honest, but they're not honest, they lie all the time, but believe them in this one instance. Make it make sense. Or reliable about Judge Mata's father, or even statements made by Judge Mata's father himself. It is ordered denying petitioner's motion for change of judge for cause. It is further ordered denying respondent's request for leave to file a supplemental affidavit for attorney's fees and costs. It is further ordered denying respondent's request for this court to enter further orders pursuant to Rule 8.2a of the Arizona Rules of Professional Conduct. It is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions. Hey! Yay! Look at that! Turns out I didn't have to go sharing it or searching for it because Jingers posted it. And with what he posted, we are going to look at what his tweets are for this afternoon. So he says, news ruling just received from Fisk. Summary, Clayton wins again, yawn. Basically, Fisk admits Mata's ruling contains findings that were not based on the evidence, but then says this isn't necessarily proof that Mata broke the rules. Yes, because it's negligible. If that would have been the only thing, like Jingers gives me a headache. Let's see who replied to this. Oh, he replied to himself multiple times. For those speculating that Mata has memorized the business hours of every Planned Parenthood location in America, I think that is probably not realistic. And this was one of the things we should have asked Mata at the hearing I requested, but Fisk denied the hearing because no reason. She denied the hearing because you did not provide evidence. Oh my goodness. Yeah, Flash fan, if you haven't heard about this case and like all the BS that is in it, it's definitely it's definitely one for the books. So we just need to wait for Mata to sign off on a final judgment, and then we're off to the Court of Appeals. I strongly suspect they will find these events shocking and entirely unacceptable, but who knows? Maybe the appellate court is also obsessed with reality TV stars. Good Lord, this dude's obsessed with himself. One final thing. I skipped one. P.S. Fisk notes that factual errors in a judgment can be fixed with post-trial motions. This is generally true, except Woodnick's deadline to file such a motion has long since passed, and judicial bias is not a fixable error. So we shall see what happens. One final thing. JFC will say this is a total vindication of Mata's actions. That is, of course, a lie. Fisk does not say Mata did nothing wrong. In a nutshell, she says we failed to prove Mata looked at social media. I, of course, respectfully and strongly disagree. You didn't prove it. Stating it over and over and over and over and over again is not just stating something, an opinion over and over and over again does not make it fact. Oh. Look at me, Daddy. I'm a real judge now. Oh my God. The fact that he wrote that in emotion, like, I just, that is like, so to recap, Laura asked for confidentiality. This was August 10th. So this was Saturday. Laura asked for confidentiality. Yeah, after going to The Sun and multiple other shady news outlets, Clayton not only opposed this, he asked for sanctions because Laura had the temerity to make the request. The court sided with Clayton and refused to allow anything to be designated confidential because that's what Clayton wanted. Yeah, Flash fan, the Tonsil Twins case is quite possibly the most crazy case I've ever seen in my life. The one where you think when it can't get any weirder, it gets weirder. So then there's this that I wanted to discuss. And then I have to get off of here because I have to make sure she eats because she is not eating because she's sick, but also she is in the first percentile for weight according to her doctor, and she has her dad's body type, beanpole, and we need to get some weight on her. So I need to go make sure she eats a lot. But this, May 28th, 2020, this was the State Bar of Arizona. So this is where he filed a bar complaint against someone else. Dear Mr. Gingras, I reviewed your submission regarding Mr. Somebody and discussed with you some of the questions I had regarding your submission. After my review, I have determined further investigation is not warranted at this time and our file has been closed. The issues you raise, such as allegations of frivolous claims and lawsuits, he alleges frivolous lawsuits. Has he met, and Laura is not? Oy. I looked at the nurse practitioner today and I was like, this and that, she got my face and my cheeks and my hair. Her dad's body, tall and skinny. Yeah, she's had pulled pork. She loves it. I actually need to have Mr. Squid smoke a pulled pork because I could really use all that meat and she could really use it too. Ugh. The issues you raise, such as allegations of frivolous claims and lawsuits, perjury, I like how he underlines this, false and misrepresented copyright claims, and inappropriate action and misrepresentation under Digital Millennium Copyright Act are legal issues that require a determination by a court of law. As you involved in current ongoing civil litigation, the court is the appropriate venue at this point to address issues related to your case, as the court is the most familiar with the facts, rules, statutes, and case law for your case. Oh, trust me, Denise, I would love to donate 30 pounds to her. She could have, pulled pork is one of the best foods. Next time we smoke a pulled pork, I will document it and I will show it to you guys. I don't really have anything to do with that. I've smoked two pork butts in my entire life. That is Mr. Squid's area of expertise. I can cook, but I cook not to die. He loves it. He loves to cook. It is inappropriate for the state bar to get involved in active cases except under certain circumstances not applicable here. For your allegations that federal crimes were committed should be addressed by the appropriate law enforcement agency. The state bar has no authority to investigate criminal activity. If the court concludes Mr. Redacted acted inappropriately, please provide us with a copy of that written court decision for further consideration. Until then, this matter will remain dismissed. Pursuant to Arizona Supreme Court Rule 71, a state bar file may be expunged in 3 years. So that was a bar complaint he filed against somebody else. And he's throwing a hissy fit because someone filed a bar complaint against him. we don't have time for that right now. I am not feeling up to going all through that. I would love to, but like my throat is starting to hurt and I don't want to lose my voice for tomorrow night stream and Thursdays. Or Friday, Saturdays. Oh my goodness. This is how my week has gone. I don't even know what day it is. If the Sarah Boone hearing is out, I will probably do a stream tomorrow morning. Because I've been valuing my sleep lately. I will probably do a stream at 10 a.m. tomorrow. And then tomorrow night is Politics, episode 4. We are doing a deep dive into Tim Walz's military service versus J.D. Vance's, and figuring out and discussing, is military service required for to serve in office, and what level of service? Should you be an officer? Should you be enlisted? And what constitutes stolen valor? So we will discuss it all. I enjoy having your input on all of this because I have ideas of what I think, but I present the information and I let y'all make your own decisions. But as a vet, I have a lot of opinions on this, so we shall see. Waltz lies, that's the difference. Van said he doesn't fault his service, he faults his lying. Yes, and we'll get into more of that. Mr. Squid wanted me to do a FOIA request on Waltz's military service, but that would take at least some time to get back. And yeah, nuance, and we'll discuss nuance as well. Yeah, and these are all topics, all these comments that we will discuss tomorrow. Tomorrow at 9:00. 9:15 if she doesn't want to fall asleep on time. But hopefully, being as sick as she is, she's not that sick, but like she's fatigued. So hopefully she'll want to fall asleep on time at 8:30. And at 9:00 I can start my stream. But we shall see where that goes. Anyway, I'm gonna hop off of here. I gotta cook dinner. And I gotta get her situated and make sure she eats. And then before Mr. Squid gets home. Military did not mean the psychologist said my problem with authority was an obstacle. Yeah. What was that? Okay, Casey Anthony. Like, thank you. I hopefully will feel better. It's not as bad as I thought it was going to be, but it is annoying when your throat hurts and you have to talk. Like, I love streaming, but it's a lot of talking. But I will see you guys later. Thanks for hanging out with me today. Baby Squid says bye. And make sure I'll see you guys tomorrow morning. Make sure you like this and subscribe if you haven't. Like the stream, share the stream. It's a work in progress, but we're trying to get to 500 and 3,000 watch hours. I am up to 2,020 watch hours. So we're 2/3 of the way there. I can't stress to you enough how much each and every one of you mean to me. I will see you guys later. Have a great day. And remember, take care of